Good afternoon, viewers, and welcome to the 7th episode of the Futsal868 Corner Talks. My name is Geoffrey Edwards. I'm your host and president of the Futsal Association of Trinidad Tobago. The Futsal868 Corner Talks is a weekly online meetup series where global sporting professionals share their experiences and perspectives on the fastest growing indoor sport in the world, futsal. Our hope is that the platform sensitizes and educates our viewers whilst we grow the sport in Trinidad and Tobago and the wider Caribbean region. Today, in keeping with our May Matters schedule, we talk sports law and futsal. Our first guest, is Mr. Roy Levy, a Swiss attorney at law with 15 years in employment and sports law. As a leading expert in the field, he has vast experience in successfully representing players, agents, coaches, clubs, and federations before FIFA, UEFA, and the Court of Arbitration for Sport in various disputes like contractual regulations and disciplinary matters. He's a member of the Swiss Sports Law Association and the International Association of Sports Law. In 2019 and 2020, he was selected by Who's Who Legal as one of the leading experts in sports and entertainment law in Switzerland. So we want to say good day to Mr. Levy. Good day, sir.
Hi, how are you?
I'm fine, thank you. It's a privilege to be able to have you here with us, considering you being my lecturer at Neuchâtel.
Yes, my pleasure to be here too.
So our second guest is Mr. J. Tyrone Marcus, an attorney at law affiliated, admitted to practices in Trinidad and Tobago, Jamaica, and Barbados, and a joint lecturer in sports law at the University of West Indies, St. Augustine, Trinidad, and a past member of the Nausicaa Volleyball Legal Commission. He was a former board member of the Caribbean Regional Anti-Doping Organization, a past legal advisor of the Ministry of Sport and Youth Affairs, and a past chairman of the disciplinary committee of the Trinidad and Tobago Professional Football League. He previously served as a legal consultant for Canuck Broadcasting Incorporated, the Caribbean media rights holder for the Rio 2016 Olympics, and has been specializing in sports law since 2006. He has a master's degree in sports law and practice from the De Montfort University in Leicester, England. He's the author of Sports Law in Trinidad and Tobago and is a co-author of Commonwealth Caribbean Sports Law. He has published numerous sports law articles and presently he's the president of the Trinidad and Tobago Association for Sport and Law. Good day, Mr. Marcus.
How are you? Hi, good afternoon. Thanks for having me.
Definitely. Before we continue, it is important that these two gentlemen, I need to let the audience know that these two gentlemen has been a great source of inspiration and motivation to my life and to where I am presently. Mr. Marcus was my referee to enter the FIFA Master, and he has, just the way he cares about himself, has been a role model to me, directly and indirectly. Roy has taught me in Neuchâtel, Switzerland, where in 1 hour he was able to break down a topic that we will speak later on that is dear to many Caribbean athletes, and I was so blown away by it that I said to myself, I went to him after class and I said, "Sir, is it possible you could come and do this in Trinidad and Tobago?" He said, "Anytime." And here he is now keeping his promise. Before we continue, we want to be able to note that these are the two books I mentioned. As regards to Mr. Marcus, that you all can take if it is you want to learn more about sports law and more about sports law in the Caribbean and Tobago. Definitely, it is a must-have and a must-read, and I'm sure that you can contact him to get it autographed as well. So, without further ado, in understanding sports law, I want us to take a little time, if I may, gentlemen, to take a little time to be able to go through the definition of sports. And this definition has been by the Council of Europe. It's very important to note that there's another definition that is more applicable to what we are speaking about. The practicing of discipline governed by a structured and hierarchical organization whether national or international, with a view to organization of competitions. With that in mind, gentlemen, in our first segment, I asked you all the question, what is sports law? I will start with you, Mr. Roy. How could you define sports law?
It's a difficult question. What is sports law? Sports law is very broad. Sports law, in my opinion, has basically two parts. One part is the lex sportiva, what we're calling. The lex sportiva is basically entails all the regulations of the big federations, mainly FIFA, of course, when we talk about football or UEFA. These are regulations that are specifically made for the competition, for the football competitions, and in order to, well, if there is a dispute, in order to resolve this dispute within the football industry, they call it the FIFA family, within the football family. And these regulations, they apply to basically all football that is played all around the world. And whenever there is a dispute, this dispute would then go to a judicial body of FIFA. So this is one part of sports law. It's the lex sportiva, which is very specific to sports. And then there is the other part, which is I would say the normal law, the ordinary law, but with a touch of sport. It can be image rights of athletes and players, naming rights. It can be any contract with sponsors that they have, other business partners that they may have. So this is normally just a normal type of law, contract law, for instance, tort law, and any other type concerning sports. So I would say these are the two main characters of sports law.
Mr. Marcus, same question to you, sir.
Yes, I think Roy has really encapsulated it well. And it really does summarize what tends to be an interesting academic debate as to whether is it really sports law or sport and the law. So as Roy would have indicated, this marriage of legal principles to the sporting industry, the proponents of sport and the law would simply say all you're doing is taking well-established principles, property law, intellectual property, contract, constitutional law, and applying it to the sports sector. But those on the side of the lex sportiva, those who say that there's a pure sports law, would suggest that sport has developed and established its own specific rules and regulations that are very unique to sport. So one of the things, for instance, and Roy would be very familiar with this, when you have disputes at the Court of Arbitration for sport, very often the panel has to decide on what is called the comfortable satisfaction. And that is a standard of proof that is very unique to sport, because usually, whether on the criminal side of the law, you would have beyond reasonable doubt. And on the civil side of law, you'd have a balance of probabilities. But here in sport, you have this standard called the comfortable satisfaction, very, very unique, all right, to the sports sector. So it really is, sports law is the overlap of the industries of sport and law. And again, depending on where you sit or where you practice, you may have the purist saying, yes, sports law is now its own established arm of the law. And you'd have others saying, man, no, all we're doing is taking established principles and applying it. Whatever you call it, sport and law have come together. And we see it very well established, of course, in Europe, and really has grown in the Caribbean over the last 15 to 20 years.
It's very interesting that we started speaking to the definition of sports law, and I want our stakeholders, our viewers, to be able to understand the following. And this was what was taught to us at the FIFA Master as well, that there's something called the pyramid of sport, where athletes are the base, member associations, and international federations. And you would have heard that Mr. Marcus would have spoken to CAS, and you note where the arrow is pointing, where legally challenges can go through CAS in terms of athletes and member associations to challenge international federations. Then there's the other side of it in terms of the pyramid of sport, whereby being monopolistic, international federations, regulations are issued from top to bottom. And this relationship has led to what we know as sport law. With that being said, the question now have to be asked is, what is the court of arbitration? Why is the court of arbitration for sport important to these members in the pyramid of sports? I will start with Mr. Levi.
Well, because it is the International Sports Arbitration Court that resolves any international sports disputes across the globe for those, at least for those federations and those sports that have put in their regulations that they want to bring a dispute to the Court of Arbitration for Sport. And it has started as a very small sort of sports arbitral tribunal, and it has developed into a massive organization with over 1,000 cases per year that they're dealing with. They have now or are now going to move also to a bigger building because simply cannot accommodate all the legal counsels and the whole organization that they need. It is a very important institution in sports law. I myself, I am representing many athletes and organizations before the Court of Arbitration for Sport. And it is based in Switzerland, in Lausanne, in the French part of Switzerland. And therefore, as a Swiss lawyer, I have a privilege because many times Swiss law applies to these disputes, even if they are taking place in some other countries, in other jurisdictions. Even if we have a foreign player playing in a club outside of Switzerland, still most of the time Swiss law applies. And therefore, as a Swiss lawyer, I have a big advantage, and also because the decisions, the awards of the Court of Arbitration for Sport can be appealed to the Swiss Federal Tribunal.
And this is why we have both of these gentlemen here. I want our guests to understand that, especially those who are listening from Trinidad and Tobago, given the fact that we are hearing from one of our major national government bodies as regards to the word CAS being thrown around on a daily basis in the news, a lot of persons are not aware of what CAS is. And here we are trying to simplify it as best as we can. And so now I throw it out to Mr. Marcus, given the fact that we will have a lot of Trinbagonians who will be watching us live, and also Caribbean individuals who will be watching us live. Can you further break down to our stakeholders your view of CAS? What is CAS? Why is CAS important to sport? Why is the CAS important to Trinidad, Tobago, and the Caribbean?
Absolutely critical. As Roy would have established, CAS would have been born somewhere around 1983, 1984, really starting very slowly in dealing with sports-related disputes, and really has now become established as the Supreme Court for world sport. And what you have, the Court of Arbitration for Sport, it's governed by the Code of Sports-Related Arbitration. And CAS itself has a governing body called the ICAS, the International Council for Arbitration for Arbitration in Sport. And they are the ones who would appoint the mediators and the arbitrators for CAS. And they want these arbitrators and mediators to have experience in international arbitration and sports law. So what you have, Geoffrey, you have a specialized entity, a specialized body, where people who have sports-related disputes have the confidence that the arbitrators and the mediators understand the industry very well and understand the nuances of the disputes that would happen within the sports sector. Now, for the Caribbean, CAS remains somewhat distant, both geographically and financially. And CAS introducing legal aid a couple of years ago has bridged that gap. But we still have a challenge within the Caribbean just in terms of having access, simply because of the costs. But if you really want to have the best chance of a well-ventilated sports-related dispute, CAS is a place that you want to go. And it has a couple of divisions, an ordinary arbitration division where, it acts as a first instance court. And then you have the appeals arbitration division, which is where many decisions are made. Most of the CAS awards are at the appeals division, and they recently introduced a specialist anti-doping division as well. So even though CAS remains a bit at a distance with its main headquarters in Lausanne, Switzerland, and with decentralized offices in New York and in Sydney, even for Caribbean athletes who, in fact, a number of anti-doping disputes involving Caribbean athletes have gone before CAS, one or two related to football, all right, but most of them related to anti-doping and track and field. What you have is really just your best chance of the people understanding the industry and giving you sports justice, access to justice, which is what ultimately athletes want.
We have heard that CAS is independent. Can you all verify such? We have also heard in the news that they're the big bad wolf. Are they? Are they not? I want to throw that out to you guys because I really want our stakeholders to understand. Hey, I mean, who are they? What are they? Are they independent? Are they the big bad wolf? Sir Roy?
So, the CAS, as Mr. Marcus already mentioned, the arbitrators which are dealing with the case are all on a closed list of arbitrators. There are, I think, around 400 arbitrators so far on this list. Divided into countries, into specialities, gender, etc. So you can choose, each party that goes to the CAS can choose its own arbitrator from that list. There is also a special football list, which I think entails around 100 arbitrators that are specialized in football. Now, these arbitrators are selected by the ICAS, by the council, the organization that is above the CAS, basically organizing the CAS. And these are all specialists in sport. All these arbitrators are specialists. They are either lawyers or judges or professors with a very rich background in sports law. Are these arbitrators totally independent? I don't know. But what makes the Court of Arbitration of Sport as an independent sport, and it has been declared independent court of sport by the Swiss Federal Tribunal many times. The Swiss Federal Tribunal, which is the highest court in Switzerland, has given the approval stamp to the CAS that it is completely independent. And why? Well, because both parties can choose their own arbitrator, and then the CAS itself will then nominate the chairman of the panel.
Mr. Marcus, are they the big bad wolf? Because many times us in the Caribbean, if it is we don't understand something, we say they're not good. We don't want any part of it. Are they the big bad wolf?
No, they're not the big bad wolf at all. I mean, the Court of Arbitration for Sport, the sports industry sees this institution as our friends. And even though you're dealing with arbitration where you will have a winner and a loser with the arbitral award, ultimately one of the reasons why CAS has really grown so much and so many international federations have subscribed to its jurisdiction is just the high quality of awards that have been produced year after year in so many sports. So I think there's a great confidence in CAS, and it really does also connect to the question of independence, which Roy spoke about. And, back in 1994, a case involving someone called Elmar Gundel, all right, there was a challenge to the independence of CAS, simply because CAS was the brainchild of the International Olympic Committee. So the question was raised, well, what happens if the International Olympic Committee is actually a party to the arbitration? Wouldn't the CAS arbitrators feel conflicted, just given the ties, even financially, etc.? And that really became the birth of the ICAS that Roy would have mentioned as well, just to ensure that there was a separation. So there really aren't question marks, as Roy indicated, constantly The question of independence has been reaffirmed. More recently, we had a speed skater from Germany by the name of Claudia Pechstein, who sought to challenge this question of independence and whether the arbitrators were more friendly towards sporting bodies as against athletes. And different safeguards have been put in place to ensure, again, that there's fairness and impartiality. So every so often, a case will come along to just kind of test this question of independence and impartiality, but CAS has been passing with flying colors. So there's great confidence in what it's doing, and people will continue to subscribe to its jurisdiction.
And to those who are joining us, this is the 7th episode of the Futsal 868 Corner Talks. We are speaking futsal and sports law. We are going to take a quick break, but before we do, this is our fun fact, futsal fact. So welcome back to episode 7 of the Futsal 868 Corner Talks. Today we speak futsal and sports law, and we have two distinguished gentlemen, Mr. J. Tyrone Marcus and Mr. Roy Levy, two prominent sports lawyers in the field. And we want you all to understand that we have gotten, as Futsal 868 Corner Talks is, where the sport experts, the sport leaders meet. We continue our conversation as regards to the conversation to CAS, and I go straight to Roy. Can you simplify a CAS proceeding for our viewers?
Yes. Well, there are mainly two different types of procedures. As Tyrone already mentioned, there is the ordinary procedure, which means that the CAS acts as a first instance body where you need a contractual clause, an arbitration clause in the contract that says that any dispute can be brought to the Court of Arbitration for Sport, and then the Court of Arbitration for Sport will decide on this contractual dispute as a first instance. The majority of the cases, however, are dealt in the appeal, so-called appeal procedure, which, as the name already says, is an appeal proceeding where you appeal a decision of a sports body, of a sports organization. Mainly nowadays, it's FIFA decisions rendered by the Dispute Resolution Chamber or the PSC of FIFA. Those decisions you can appeal to the Court of Arbitration for Sport. Usually the timeline to do that is 21 days, unless the organization provides differently. And so within these 21 days, you will need to submit the a statement of appeal. In this statement of appeal, you don't need to already substantiate your claim. You will only need to basically explain who are the parties, what you need to provide a decision, which decision you are appealing, and nominate an arbitrator. As I said before, you can choose from the list of arbitrators who you want to nominate. You have to pay 1,000 Swiss francs as a court office fee to the Court of Arbitration for Sport, so that they will open a case for you. And that's it. And then you will get, once this is done, you will get another 10 days, during which you can then submit your appeal brief, which is then a more substantiated submission. These 10 days, however, can be extended. So you get a bit more time for that.
Mr. Marcus, can you give us some prominent examples of Caribbean or Caribbean, examples of sports law. I think that we made of sports law, going to, or examples of Caribbean cases going to CAS.
Geoffrey, let me just ask you to repeat that. I think I went out for 5 seconds.
That is the joys of live TV. Yes. What can you give us some examples of prominent Caribbean cases that went to CAS from your recollection?
Yes, absolutely. I mean, I mentioned earlier quite a number of anti-doping cases have gone before CAS, and we would have had in 2013. 2013 is a year that stands out in my mind because track and field would have had a number of athletes in that very year. We had Seymour Hackett and Killian Batiste from Trinidad and Tobago, Asafa Powell, Sharon Simpson, Veronica Campbell-Brown, all from Jamaica. And you know, these and there were varying results, from Veronica Campbell-Brown being completely exonerated because of pretty much a botching of the doping control process between the doping control officers, the sample collection, the storing of the samples, the possibility of the sample being compromised. Asafa Powell and Sharon Simpson having their suspensions reduced from 18 months to 6 months. Killian Batiste, Seymour Hackett having a settlement even before the hearing was actually heard. And then more recently, we would have had a very high profile case involving Nesta Carter from Jamaica. And this would have been important because this would have been the 2008 Beijing Olympics, where he would have been a teammate of Usain Bolt and Asafa Powell. They would have won the gold medal and eventually lost it because Nesta Carter would have tested positive. What made that case very interesting was that his positive test came 8 years after the Beijing Olympics. At that point in time, the World Anti-Doping Code had a statute of limitations, of 8 years, which would have given the World Anti-Doping Agency, excuse me, gentlemen.
We definitely know it's not Corona. We definitely know it's not Corona. You're quite fine. Healthy guy.
Well, I'm keeping social distance from both of you all.
Of course.
Sorry about that. So yes, the Nesta Carter case, because of the 8-year limitation period, it really would have allowed his sample to be retested up until 8 years after the Beijing Olympics. And though at the Beijing Olympics there was no positive test, the positive test came 8 years later when there was an increased science. So it was quite an interesting legal argument, but eventually, he was stripped of the gold medal as well as the rest of the team. And it really meant that Usain Bolt, who got 9 gold medals over the course of 3 Olympics, it was reduced to 8. So I would highlight those as some of the main ones. There have been some others involving a cyclist from Guyana, track and field athletes from Bahamas, from Barbados, etc. But none as high profile, I would say, as the Nesta Carter case, because it involved, a global legend in Usain Bolt. Outside of that, not many other sports have really had their matters ventilated before CAS.
We're going to take a quick pause as regards to the situation with CAS. We will come back in another segment, and we want to dive into the case study that we will put up on the screen. But this is very important to me as a sport administrator, and also to the stakeholders we speak to in terms of coaches and players. And again, I want to repeat, I was blown away when Roy was able to break this down simple to the point where, that is what we are. But when we were promoting this segment, or I should say this episode on social media, a lot of Caribbean players contacted us because it's something that we has been affecting our industry, the sporting industry in Trinidad and Tobago for a while. So for our viewers, this is the case study that we are going to look at. The unpaid professional football/futsal player, for which I would first have Roy teach them, as you taught me that case study, and then we'll speak to Mr. Marcus some more in regards to that.
unpaid football player, is that it?
Yeah. So it is a case study, the unpaid professional football or futsal player.
Right. Well, unfortunately, it's something that happens, very often across the globe on a daily basis. Futsal or football player are not being paid properly, are not being paid on time. Not the entire salary is paid, and unfortunately, many players don't know their rights. They don't know what to do. They don't know how they can approach the club. What rights they have. Oftentimes, they are based in a foreign country where they do not know the language, do not know the culture, etc. Don't know any lawyers that can help them. So FIFA has, if we're talking of international dimension, and this is important because only then FIFA applies, only if there is an international dimension to a dispute, meaning if it's a foreign player playing in a foreign country, not a domestic player in its own country. And so FIFA has put regulations in place which allow or which give the tools to a player to make claims to FIFA judicial bodies, to put pressure on the club to pay. There are certain articles which, if the player invokes these articles, the club will be sanctioned by FIFA. Sanctions can start with a warning, a reprimand, or then go to a fine, or even a ban of registering new players. So there are many ways for a player what he can do in order to receive his salary or his payment. The important thing is, the first thing you always need to do is you need to give a deadline to the club. I would say 10 days is a minimum that you need to give, 10 days deadline, then he has to pay, or 15 days if you think about terminating your contract. Terminating a contract is something that is more severe, of course, and it can only be done according to the FIFA regulations once 2 full salaries have not been paid, and on top of that, you have given the club a deadline of 15 days, 15, to pay the outstanding salaries.
No, go ahead, Mr. Go ahead. Mr. Marcus, you have been part of the Trinidad Tobago professional league, football league. When it comes to unpaid salaries to players and coaches, what are the rights of this demographic?
Yeah, the situation in Trinidad and Tobago and the Caribbean is quite different from Roy's experience, especially because of the applicability of the FIFA regulations, etc. So, for instance, my experience with the Trinidad Tobago Pro League would have been with the disciplinary committee, all right, and that would have dealt with just the disciplinary offenses on the field of play, straight red cards, etc. But side by side with the disciplinary committee would have been the player status committee of the Trinidad Tobago Professional Football League. That would have been the committee to deal with issues of unpaid salaries, late salaries, broken down contract negotiations, etc. Now, on both committees, what the Pro League would have done, it would have incorporated by reference the FIFA regulations. So for the disciplinary committee, that committee incorporated by reference the FIFA disciplinary code. The player status committee would have incorporated by reference the FIFA regulations on the status and transfer of players. And as Roy would have indicated, and he would have had a lot more hands-on experience with that, especially being based in Switzerland. But you look at the jurisprudence coming out of CAS, and you see that the players have often sought to get legal redress using 2 limbs. Number one, a breach of contract, all right, and some of the time periods that Roy would have indicated, would apply. depending on the particular contract or depending on the regulations, you would have needed to give a certain amount of notice. The unpaid salary would have had to be for a certain length before you could bring in a particular claim. And then what footballers would also try to do, besides the breach of contract claim, they would also try to get compensation, all right, by invoking Article 17 of the regulation, the RSTP, the regulations for the status and transfer of players. And sometimes they've been successful under both limbs. Sometimes they've only been successful under one. The experience, I was able to speak with a former chairman of the Player Status Committee in Trinidad and Tobago, and there really weren't that many situations that came before the committee. I think probably it may simply have been just a lack of knowledge that this forum was available. And so I think within Trinidad and Tobago for sure, and probably within the wider Caribbean, this aspect of player redress is something that will continue to grow. I think it's still very much at its embryonic stages, but the case law coming out of CAS has been very helpful in terms of understanding the principles that would apply and the way that CAS would have dealt with appeals, whether from the FIFA Dispute Resolution Chamber or the FIFA Disciplinary Committee or the FIFA Player Status Committee. But Roy's first-hand experience definitely has been very helpful in just kind of painting that context.
So a 14-year-old young man who is aspiring to be a professional football player, whether it be in his own country or internationally, and even one who is presently a football player and plying their trade, he is a Trinbagonian national, but plying his trade either in Trinidad and Tobago or internationally. But with both scenarios, they're not getting paid. What do you tell that player? And I'd ask Mr. Marcus to start with you first, please. I mean, I know that we will have touched on it, but I would like to go a little directly. What would you tell that player? What advice would you give to that player?
Yeah, as lawyers are always starting off by looking for what are the potential causes of action. And the first port of call would typically be a breach of contract. All right, the case law coming out of CAS will tell you that this is the primary obligation, all right, of the football club as an employer. So there are a couple of things you want to establish. You want to establish indeed that there's an employment relationship. That's important to establish the relationship between employer and employee, and just the legal backdrop to establishing an employment relationship. Then you want to look at the terms of the contract to ensure that indeed there was a breach, all right? Because sometimes, in a contract, you may have a clause that says, all right, in the case of a breach, all right, they may give the party in breach a certain period of time to remedy the breach before they think about invoking some kind of action. So if you have this unpaid player, then you're going to go to the contract terms to see, okay, is there this clause that gives a little bit of leeway? Maybe I haven't been paid for 1 month. All right, maybe that is the very time frame that the club is allowed a certain amount of leeway, and then the responsibility would be to bring it to the club's attention. Hey, this is what is going on, and Roy spoke about that. There is an expectation that before you think legal action, you make your employer aware. Look, I haven't been paid. All right, this is a breach. I'm going to give you 7 days. I'm going to give you 10 days. I'm going to give you 15 days to remedy this. If you don't, then I'm going to pursue legal action. All right, so these are some of the prior steps that you would take before going, along the breach of contract route. And like I said, if the RSTP applies to your particular context, whether directly because you're in an international setup or by reference, then you can go typically to your Article 17 and try to get some sporting, what they would call just cause termination for just cause, which would allow you to get some compensation outside of what the damages you would get for breach of contract. So that would be the typical route for an unpaid player in a Caribbean context or Caribbean player in an international context.
If I may ask, Roy, given the Caribbean player is plying his trade in Europe and he engages in that, or he has that issue, that problem, what would you advise him? How would you advise him to get in contact with a prominent lawyer to be able to assist. Because what I've come to recognize is, and your gentleman could tell me if I'm wrong, I think Mr. Marcus would have mentioned it, is that lack of knowledge. There's a clear lack of knowledge by our players as regards to how they can be able to find redress. How can someone, a player from Trinidad Tobago, Jamaica, Barbados, and Lucia, who's plying their trade in Central America, South America, Europe, get in contact with somebody like you, Roy, to be able to fight for them in terms of their cause? And what would you be looking out for to be able to assist them?
Right. Well, first of all, they can always contact me. I'm happy to assist them, to answer questions. So if they like that. Otherwise, there are players' unions in almost all the countries. There is the International Players Union called FIFPro, which is based in Holland. They can contact this organization, and they can then guide them to the right person or the right organization. And what would I advise this player? I think Tyrone already said very correctly. What has to be done. First, you have to look at the contract. First, you need to understand what has been agreed. I personally would also look at the law that applies to the contract. This is also very important. Is it Swiss law? Is it any other type of law? Did they apply the regulations of FIFA, or do they apply at all? And then, I would certainly try to find first an amicable settlement or just basically contact the club. What's going on? Why haven't you paid? Are you in financial difficulties? Is it because of the Corona crisis? What's going on? Try to find out, to figure out what is going on from the club's perspective, and then eventually, basically, move up the ladder. Try to first give the club a deadline to pay. If it doesn't pay, you can take legal actions with FIFA and sanction the club. If the club still doesn't pay, basically the last resort then is to terminate the contract with just cause. But you have to make sure that you have just cause, because if you don't have just cause to terminate, you can be in trouble. The club can then ask compensation from you.
Question from one of our guests looking online, and this is to you, Roy. Can you give us an idea on ways that an agent gets paid for representing players and coaches? Thank you, Mr. Constant, for your question.
Ways that an agent can get paid representing players and coaches. Well, you find different ways. You find that an agent will receive a percentage of the player's annual salary. That can either be just the first year's salary or the salary of the entire contract period. It can be a percentage of the transfer fee. It can be any type of remuneration, really.
So with that ends our second segment of episode 7 of the Futsal 868 Corner Talks. We're going to take a quick break, but before we do that, I want you all to remember that this show and every other episode can be recapped with our program, on our Facebook page and our YouTube channels. Keywords Futsal 868, as well as we have a partner. When I say thank God for that, the opportunity to have a partner, check us out. Welcome back to episode 7 of the Futsal868 Corner Talks, where sport leaders meet. This week we speak sports law and futsal. We have with us Mr. J. Tyrone Marcus and Mr. Levy, Trinidadian and Swiss respectively, experts in their field of sports law. In this segment, we have a bunch of questions that we collated from persons during the week as regards to football, futsal, and different topics. We know that sports law is broad, but we want to go straight into it. And our first question is as follows: does FIFA recognizes the term semi-professional athlete or league? Mr. Marcus.
Yeah, one of the starting points would be the FIFA statutes, all right? And that would apply whether that question will post UEFA, CONCACAF, CONMEBOL, etc. What you would tend to find within a constitution would be your membership structure, your definition sections of different types of members. And that would really determine if FIFA would recognize a semi-professional setup. All right, and even at a lower level, an amateur setup. Exactly how would they deal with it? Of course, with FIFA being the world governing body for association football, all right, they would really be dealing with football above the amateur level. So I think the short answer I would give to that is, okay, what do the statutes say? What does the constitution say in terms of the membership setup, and whether a semi-professional league can actually qualify, whether as an ordinary member or some other type of membership category. And like I said, that would apply to any one of the confederations. Your starting point would be, what do the statutes say, and whether it contemplates, all right, such a setup.
To my Swiss lecturer.
Regulation on status and transfer of players, which says in Article 2, players participating in organized football are either amateurs or professionals. A professional is a player who has a written contract with a club and is paid more for his footballing activity than the expenses he effectively incurs. All other players are considered to be amateurs. So according to this regulation, there is only, you're either an amateur or you're a professional. There is no such thing as semi-professional when it comes to players.
And with that, I want you all to get it again. There's no such thing as semi-professional player or league. This is something, a terminology that has been thrown around the Caribbean, and it is ridiculous, I must say. And this Sunday afternoon, I have to hold my tongue, Mr. Marcus. But it is truly ridiculous, and I want to say thank you very much for answering that question. We move on to the second question. The structure of a professional football futsal league in a member association, does the structure of a professional football or futsal league in a member association affect litigation against non-payment of revenues for players or coaches? And the back end or the background of that is because there are many different league setups in member associations, some whereby the government subsidizes, some whereby it's a private organization. Does that affect the litigation in terms of non-payment of revenues to players or coaches? Mr. Marcus.
That question, yeah, the answer to that question is, to me, less about the actual structure and more about exactly what the dispute resolution setup contemplates. All right. I mean, I'd start off by saying access to justice, through the courts is something that is fiercely protected under the common law legal system. All right. And so the question to me really is, okay, does the dispute resolution setup, all right, contemplate litigation? Are you allowed to go to your national courts, or must you go through so if it's non-payment of a coach or of a player, must you go through first and foremost amicable settlement negotiations, and if that fails, then mediation, and if that fails, then arbitration, and then if all of that fails, then you still have access to the High Court. So my answer to that question is, I don't know if it really depends on the structure per se. I think that question really more speaks to what does the dispute resolution setup within the governance structure of the sport contemplate.
So Roy?
If it is an international dispute, so a foreign player playing in another country, then the FIFA regulations will apply. And even no matter what kind of structure your league or your organization has, you still have a competent judicial body within the FIFA organization to take the dispute to.
Thank you very much. So the third question in this segment goes as follows. Does FIFA recognizes football unions in a member association? So, Roy.
Yes, it does. There are many football unions in across the globe in many member associations, and in the regulations you always find articles where it says this and this applies unless there is a collective bargaining agreement, for instance, in a specific jurisdiction that would prevail.
Mr. Marcus, I would ask the question to you in a different way. Would you suggest then, with the answer given by Sir Roy, would you suggest that Trinidad Tobago and the Caribbean islands have players and coaches member unions?
I smiled when I saw the question, because this has had such a turbulent history in a Trinidad and Tobago context, in particular years ago under Shaka Hislop and Clayton Morris. All right, Roy, these would have been just esteemed football players in Trinidad and Tobago's history. Shaka Hislop would have played in the 2006 World Cup, the only World Cup we participated in. Clayton Morris would have been the captain of the strike squad back in 1989 when we were very close to getting to Italy. These two gentlemen would have established FPAD, the Football Players Association of Trinidad and Tobago, and it really was met with resistance over the years, Geoffrey. And from time to time, there have been conversations about getting it restarted. And even the TTFA, the Trinidad Tobago Football Association, in its 2015 constitution, actually did recognize as a member the Football Players Association, but because of a lack of activity, from my recollection, they actually lost that membership, but it's something that the Constitution contemplated. So all of that to say, yes, I do think it's going to take some courage, some brave leadership from the players, because what tends to happen is that I think because of the way that unions can be viewed, players' unions can be viewed, players may be a little bit fearful as to whether if they're too strong of an advocate against administration, whether there may be some backlash. So that's my experience just communicating with Caribbean footballers.
As our tagline at Futsal 868 says, stronger together. And even as a sport administrator, it's very important that the team that works with us, we are all about ensuring that every single stakeholder are treated equally and fairly. That's very important. And I really want to thank you very much for mentioning it again as regards to getting our players and coaches unified to be able to speak with one voice and be able to add to the sporting landscape of Trinidad and Tobago and also the Caribbean. We move on to the other question. Does national law of the member association affect or influences dispute resolution between the MA and the International Federation? Don't smile too much, Mr. Marcus. Don't smile too much, because we know that this is a very weighted question, especially what's going on right now in Trinidad and Tobago. So we read it again. Does national law of the member association affect or influences dispute resolution between the MA and the International Federation? But before that question is answered, gentlemen, before you answer that question, I want our viewers to remember one thing. Let's look at this. Let's look at again the pyramid of sport. athletes, members association, international federations. Also noting that regulations goes from a top-down approach. With that being said, I turn to Sir Roy.
Okay, so I'm speaking obviously not from a Caribbean point of view, but
yes.
Swiss point of view. Well, in my opinion, the international, as you put it very nicely, Geoffrey, in your chart in the pyramid, right? At the top there is the International Federation, and they are providing the statutes and the regulations which apply to be a member of this international federation. Then underneath there are the member associations, which are a member of the international federations, and they need to comply with these statutes and these regulations. And in the regulations of the international federation, there is for sure somewhere a clause, an arbitration clause, or an applicable law that applies to any disputes arising out of this structure, right? And most of the times it will be, I would say, the law of the seat where the registered seat of the international federation is.
Mr. Marcus?
Oh, absolutely. I mean, and that is such a layered question, because sporting organizations, they like to appeal to the concept that they call the specificity of sport. And Roy would know very well, starting all the way back in 1995 with the Bosman ruling, and just the fact that, European law was seen to be able to apply, and cases even before that. But absolutely, national law continues to remain supreme. One of the things Roy mentioned earlier is that you tend to find, especially at the CAS level, that they would first and foremost, and many CAS football cases, they would first and foremost use the FIFA regulations as the first law to apply, and then subsidiarily it would be Swiss law. And even the TTFA statutes speak to similar language. We have the arbitration panel, all right, but this is always made subject to national law. National law always remains supreme, but sporting bodies tend to go first to their sporting laws, their sporting regulations, and then supplement to that, they would use the national law. But national law always remains supreme.
So with that question, I know it's a very loaded question, and I want to dig a little deeper into it. If a member association, I'll ask Roy this. What is the relationship between a member association and an international federation, and more so specifically, what is the relationship between a member association for the sport of football, futsal, and beach soccer in relation to FIFA, and how is that relation from a legal standpoint?
Well, it's a membership. It's a sort of a membership. It's an association, according to Swiss law, and FIFA is an association pursuant to Swiss law. You have to think of an organization that has a lot of members. FIFA has around, I think, 211 members. The members of FIFA are the member associations, so the national football federations. And then these national football federations, again, in like this pyramid that you showed before, they also have their own members, which can be a futsal federation, beach soccer federation, etc. And all of them are, under this roof of this pyramid. So they all, until the player actually that is registered with the club, all of them underneath this pyramid roof have to comply with the regulations of FIFA. They are the ones that are the governing body on top, and they are basically providing all the rules and regulations for everyone else in this pyramid.
We would want to see, gentlemen, that time is upon us. But before we continue, I want to really and truly, because of how much this has been useful to me as an individual, is a dream come true, because as I said before, Mr. Marcus, in terms of how him being a mentor to me directly and indirectly, being able to educate the masses is very important. And I just want to say that before we go to our last question and any further comments, I want to say thank you very much, gentlemen, for taking the time to be here with us on this Sunday evening as well and Sunday night in terms of Switzerland. So this is our second to last question. What is force majeure? And how is it viewed during the COVID-19 pandemic in relation to sports?
Roy has an advantage here because he's in a French-speaking country. Yes, force majeure is this French expression which really seeks to talk about, acts of God, unforeseen circumstances that have arisen, which really cannot be attributed to either of the contracting parties. And so once a force majeure clause is invoked, you really have no penalty, simply because, so it may be, civil unrest, earthquakes, hurricanes, and of course, something like the current global pandemic. So you would find that many sports contracts right now, that the force majeure clause is the one that people are relying on. You're not going to find a penalty attached to either party. This is not something that was brought on by their own doing.
So, Roy?
I have nothing to add to the definition of the professor, but what is very interesting is that FIFA issued the COVID-19 guidelines. Probably you have read it. And what is very interesting is that FIFA states just very bluntly that the corona crisis is a case of force majeure. Why is that so interesting? Because when you look into the jurisprudence of the FIFA judicial bodies, you will find a few cases on where one of the parties tried to invoke force majeure, but none of, to my opinion, none of them has ever succeeded to invoke the force majeure. Even in when there was a tsunami in 2004, at the end, the DRC said no, this was not a real case of force majeure. Other cases like I think the civil war in Egypt, no, it's not really a case of force majeure. So it's very interesting that FIFA in this case said this is now a clear case of force majeure.
So with that, we come to the end of the dialogue, not necessarily the show. And I want to say thank you very much to Mr. Marcus and Mr. Levy. I would like to publicly invite you all again, because I think that we just touched the tip of the iceberg as regards to sports law. I really hope that our viewers have learned something as regards to this dynamic and growing field, especially in the Caribbean region, as Mr. Marcus likes to say, and also to be able to answer a lot of the questions that has been put in the airwaves of Trinidad and Tobago, whereby we know that on the corner as well, in this case, in person's homes, everybody have turned a lawyer. In Trinidad and Tobago parlance, everybody has turned a bush lawyer. And so now we hope that both distinguished gentlemen has added value to your knowledge base. And we want to say thank you very much to both individuals for being with us. And we wish God's richest blessings unto you and your families and safety in this very difficult time. So on behalf of the Futsal Association of Trinidad and Tobago, to Mr. Marcus and Mr. Levy, thank you very much, dear sirs.
Thank you.
Well, the show has not ended as yet for us here. I just want to let you all know that up next week, we are going to speak futsal and esport, where we have with us the Trinbagonian, Mr. Kwesi Charles. He is the owner of Eagle Agency, which is a esport company, a very experienced gentleman, and we are going to pick his brain as regards to esport and futsal, noting that in this COVID-19 scenario, we have seen an increase and a spike in online gaming. Before we go, we also want to let you a throwback to the sights and sounds of the FIFA Futsal Coaching Course and Grassroots Festival.
As a group, we will seek to learn and understand what futsal really is, what it's about. Is your understanding the same as perhaps our understanding and the broader game as a whole? But importantly, we will also consider how futsal is a strategic development tool for the development of young football players.
So on behalf of the Futsal Association of Trinidad Tobago, we wish you God's richest blessings and do have a great afternoon. Thank you very much.